So continuing our discussion about what a court is for, it's important for us to really dig into what online dispute resolution is. So you'll see it referred to as online dispute resolution, online courts, or of course as ODR. And so online dispute resolution is a phenomenon that emerged in the 1990s and was initially a branch of alternative dispute resolution. I always have a bit of a chuckle when we talk about ADR, alternative dispute resolution now, because it's not alternative anymore, right? It was when I was at university. In fact, I did quite a bit of research in this space at the time with a mediator. It was really interesting research, but the idea of using mediation as part of a dispute resolution process, even just the idea of resolving disputes as opposed to just adjudicating on disputes, was very, very new in the late 80s, early 90s. But now, as you know, mediation and other alternative dispute resolution approaches are embedded into the way that we do justice in Australia. You basically cannot get a matter heard in any of our courts, a civil matter heard, unless you're able to demonstrate that you've had a go at using mediation. So anyway, I always have a chuckle. We call it ADR, we call it alternative dispute resolution, but it's really just another dispute resolution process. It's step A in the dispute resolution process as opposed to alternative, if you ask me. So when it sort of started to emerge in the 1990s, it was really seen as being a form of electronic dispute resolution or electronic alternative dispute resolution. And many different techniques fell under the umbrella term of ODR, including e-mediation, e-negotiation, and e-arbitration. Back in the 90s, if you put E in front of something, it made it kind of technology. Why wouldn't you do it? So basically what really it involved was, rather than meeting in person to conduct, say, a mediation or a negotiation, then let's find techniques that are developed to sort out a wide range of disagreements in an informal way and online, from consumer disputes to problems arising in e-commerce, from quarrels between citizens to conflicts between individuals and the state itself. So in order to think about how online dispute resolution can work, how online courts need to work, we need to answer this question. What is a court? Is it a place? Is it a service? What does it do? I've got a couple of quotes on the slide here. I'm going to read them from those of you playing along in the podcast, so you don't need to squint or make your screen huge if you're looking. The first is from the former Chief Justice of the High Court, Robert French, who pointed out it is the courts and only the courts which carry out the adjudication function involving the exercise of judicial power. Okay, so fairly firm statement there. Only the courts can adjudicate. Now, more recently, though, again, former High Court Chief Justice Murray Gleeson, the quote that I have here really goes more to that conundrum of what it is that a court needs to achieve. So he says the courts of the future will need to embrace and respond appropriately to the demands of the future while remaining a court. Wonder what that means, remaining a court. For that purpose, judges themselves, and especially judicial leaders, need a clear idea of what being a court involves. That's what we're here for, folks. This means understanding the characteristics of the judicial function and discriminating between the essential and the inessential. So this is really key. What's essential here and what is not essential? Now, this is where I'm going to challenge you to go back to the ethical principles that we have been dealing with all in the more recent weeks of this semester and think about the hierarchy of duties. think about the obligations that lawyers have first to the courts, which again is kind of ironic when we're talking about understanding what it is that a court really is and does, thinking about, well, what are our duties as lawyers and participants in the judicial system, in the system that provides access to justice. By thinking about what our roles are and what our duties are, I think it helps us get a better sense of what it is that the courts are for. I want to point you to this case, Aon Risk Services and ANU, Australian University. And this comes from a majority decision here of Justices Gummow, Hayne, Crennan, Keifel and Bell. In the past, it's been left largely to the parties to prepare for trial and to seek the court's assistance as required. Those times are long gone. The allocation of power between litigants and the court arises from tradition and from principle and policy. It is recognised by the courts that the resolution of disputes serves the public as a whole, not merely the parties to the proceedings. I'm going to come back to Aon and ANU. It's really hard to say that, Aon and ANU, a couple of times, because I think it is really instructive as the court unpicked, well, what is it that they need to give precedence to? And spoiler alert, one of the key things that the majority looked at here was efficiency and access to justice. So in thinking about what a court is and thinking about what the objectives of online dispute resolution are, we're kind of thinking about what are the objectives of a court in the first place, and can an online dispute resolution system meet those objectives as well as, or even better than, the system that we have now that involves humans and quite frankly, some technology, but probably not as much. So in order to really envisage or imagine an online dispute resolution system that totally eradicates human judges, it would need to be an expert system form of AI. The main aim of the original pioneers in this space wasn't to develop systems to support human mediators and negotiators. It was to eradicate the humans from the process. Much of the real work that's been done to develop these systems has been done in the private space. So eBay in particular, and PayPal. PayPal itself was a technology originally developed to provide a kind of trustless environment for people to buy and sell things online when buying and selling was still pretty new. It basically provided a platform that allowed a seller to be confident that they would get paid or that payment had been made and it would be released to them when the goods were sent, and allowed a buyer to be confident that they could part with their hard-earned cash on the basis that they would get it back. There was a dispute resolution process in place if the goods never showed up or weren't fit for purpose. And so a lot of the actual technology work went into developing both the PayPal system initially, which was originally a subsidiary of eBay, and then the dispute resolution systems that sit around that. Now, that's exponentially been changed in the last few years, particularly with the advent of Alibaba and the Tencent technologies that have come out of China around that, and the use of data to really develop those systems to provide for these online mediations, moderations, and dispute resolution systems. And again, the third of the readings that you have this week includes the Chinese online courts and some information about these processes. So the originators of these systems initially, ambitiously, sought to develop systems that parties could use to resolve disputes without any recourse to conventional court systems. But it doesn't really sit in the public court systems. It's still really a form of alternative dispute resolution. In fact, it's more alternative than mediation, which we call an alternative form of dispute resolution. And advocates of online courts propose that some of the techniques that have been developed for online dispute resolution could be used within the court system if we thought about the way that we used courts differently. Traditionally, there's nothing traditional about ODR. So typically is probably a better word here. Typically, an ODR process has 3 steps. Firstly, let's identify the problem and provide information. That's really what it does at the first step. Secondly, it will facilitate some kind of form of dispute resolution, so a negotiation or a third-party facilitated alternative dispute resolution, so a mediation or something like that. And then thirdly, it will provide a process or a platform for a more formal dispute resolution if the mediation is unsuccessful. So it will initiate the steps to commence proceedings perhaps, or it might be linked to a court or a tribunal system in a particular jurisdiction so that there's a seamless progression into that system from the online platform. Alternatively, the system itself could generate the forms and other documents, so letters of demand, pleadings, affidavits, those kind of things, that a user can employ to commence their own legal proceedings. So the ambition of an expert system like this will be to resolve as many disputes as possible as early as possible. The more self-resolution that occurs, the quicker and cheaper the process is for the user and the provider. So the key performance indicators for a successful ODR is really around speed, cost, and quality. But what I want to challenge you is, aren't they good key performance indicators for a court anyway? Shouldn't we be thinking about speed, cost, and quality in the process of thinking about access to justice generally? So providing information, sorry, let me go back to the steps now, just thinking about the steps. So in the first part of this, in providing information, using an expert system can be a standalone system. It could educate a user about the legal issue. So it could be something like the Don't Pay That Fine app that we talked about a couple of weeks or might even be months ago now. The semesters all turn into a blur, don't they? It's really important in an online dispute resolution system that there is a first step that provides information and that allows the users to identify who the parties to the dispute are and to map out what success is going to look like. In a traditional trial, the relevant facts need to be put before a judge. And so in an ODR scenario, the necessary background to the dispute will be needed by any kind of AI to really be able to map across similar disputes to find out what the end result should be. This first step of information and information sharing is really about diagnosing the problem and to ask a series of questions, but also to provide information so that the user themselves is educated, that they can understand what the steps are going to be, and to have some sort of insight into whether or not they're going to be successful. Information could be provided using text, could be used with videos. We're seeing more and more chatbots being used, particularly with the growth in AI using GPT-3 and natural language processors, but also through helplines, through database inquiries. Information is usually or mainly oriented to explaining why particular facts are relevant or helping in selecting the correct kind of legal category for a dispute. But it can also be aimed at developing skills like communicating with the other party or calculating the losses. The provision of information aids users to more accurately answer the questions that the expert system asks. And the better quality of the data going in about the dispute, the more likely we are to get really good results out of the analysis that the AI will do. AI can also be employed in these kind of systems to create documents that might be necessary to support dispute resolution processes. So the letters of demand or the formal stuff. So it could be an ODR can work as a self-contained process itself, but it can also interface into the traditional legal systems. So now the second step here, the second step in each of the ODR systems that the research is really focused on, and research here, I'm really just focusing on what you've got in your reading from Richard Susskind and also the Legg and Bell reading. The second step in the ODR processes is really about promoting voluntary resolution. So with or without a third party, getting the parties or the people who are subject to the dispute to nut it out themselves and reach agreement on what the end result should be. This kind of, or this step, draws primarily on technologies that facilitate communication between the parties, and if there's a third party involved, with the third party. So it might be things like text messaging, telephone or video conferencing. It could be, well, depending on whether it's synchronous, so continuous or real time, or asynchronous, the communication technologies might be different, but we're all used to using those technologies now, and they're working significantly better than they really ever have. AI that utilizes machine learning can have a role to play in the terms of suggesting to the parties possible approaches. So predictive text, if you want, on speed. AI can use the machine learning, see what the parties' information, what they've provided, and then learn from past similar disputes to suggest outcomes that might be commercial and that might work. Indeed, the AI's ability to generate options could lend it to being seen as the third party, to taking on the kind of role that the mediator has. And the third thing that we see in these ODR platforms is the utilization of artificial intelligence to create necessary forms or documents based on the information that the users have provided to move, if the dispute hasn't been resolved, into a more formal dispute resolution process. Dispute resolution processes, like the second step, primarily draw on communication technologies. Decision-making step usually remains with the humans. In a formal sense, that might be tribunal members or mediators, but in a full ODR sense, it might actually just be the participants to the dispute themselves. Can you imagine future developments where the artificial intelligence, having obtained the facts, determined the relevant law and applied it, could actually replace the judges in this process? The outcome might or could be a recommendation for a human judicial officer, or could be an AI-generated determination that could be non-binding initially. But I wonder, can you imagine a world where it might be binding in the long form? This slide here is going to be very hard for you to see, but feel free to print it out and have a look at it if you're listening along at home in the podcast or on the video, or even better, just go to the source. It's table 6.2 from the Legg and Bell reading that you have. And I just thought it was useful because it points out the different kinds of technology that are used in each of these different ODR approaches. So it looks at the technology that it's available or being used in the information intake mechanism, so where we're ascertaining facts, that kind of stuff I've just been talking about. It looks at online ADR overall, so where the ODR or the alternative dispute resolution is being conducted online and the technology is facilitating a voluntary ADR so a negotiation or mediation, and then also what technologies are being used in an online court or tribunal, so where there's being a binding determination. So I think that it's going to be really instructive for helping you focus on what the real technologies are here. Now, of course, Legg Bell, the whole book's about artificial intelligence, right? So they're looking for artificial intelligence under every nook and cranny. And I think what really stands out to me in this table is how actually AI is playing a very small role in the current technologies that are being used. Really in ODR, we're seeing a lot more automation and database use in particular. So yeah, again, have a look at that. I think the article or the chapter I've given you is really quite interesting. And it leads me really to this question, a question about questions. Are we asking the right question? Are we looking at this the wrong way? Rather than change the process, should we actually be changing the law? What are the opportunities for law reform here? Courts have been criticised for operating on the assumption that every litigant has a lawyer and court processes can proceed on the basis that users are legally trained. Indeed, self-represented or pro se litigants are the anomaly. But in many areas of law, actually they're not anomalies. That is what is happening because the cost and the delays are so incredible at the moment that it is really difficult for most people to find good representation. So if an individual confronts a complex and inaccessible court process, we risk actually that public confidence is going to be undermined in the whole the justice system overall. So the question that Legg Bell have been posing is, what would a court look like if it was designed for non-lawyers? What processes would have to be simplified and expressed in plain language? These changes could also assist us in developing online dispute resolution platforms, including AI systems. So is it right to assume that every dispute needs a lawyer's involvement? Could we redesign the process in ways to minimise that? And if we're going to do that, how are we going to decide when a human being is actually required? That apostrophe on the slide is going to really annoy me. It will not be on the slide that I share with you, I promise. One of the questions that we'll get to in a little bit more detail is this question of whether or not the AI comes with bias. But can we eliminate bias, and should we be eliminating bias? Judges come with bias. Bias isn't always a good thing. It's not always a bad thing. It is just a way that our brains and system works. One of the things that the literature, the readings that you've got will point out is that there are a lot of people who just end up not going through any process. They either just give up really early on and they get ripped off, I guess, in small commercial disputes because it's just not worth their time and money, literally time, literally money, to resolve disputes or to have them adjudicated. So is there an underserved market for dispute resolution? Could we see actually more disputes than ever if we provide a more efficient way of resolving them? And actually, should we be looking at dispute resolution at all? Isn't it our role as lawyers to find ways to proactively avoid the disputes in the first place? Oh, sorry, heading in the wrong direction. And this is the third reading, or the cover of the book for the third reading that you have today. And really one of the key drivers of online dispute resolution is this need for affordable access to justice. And so Susskind says here, two of the major benefits that would flow from online courts would be an increase in access to justice, so a more affordable and user-friendly service, and a substantial saving in costs, both for the individual litigants and for the court system itself. ODR has a lower cost structure. It provides opportunities for extending access to justice to many citizens who are at the moment effectively being excluded because of costs from the justice system. It has the potential to enhance access, not just generally, but for disadvantaged groups specifically, by removing or reducing the barriers that they have through technology. And it could also permit the resolution of disputes between parties from different countries and different cultures. The case studies that you've been asked to read, I'm not going to go through them in any detail here. They are useful. And again, without promising anything in relation to exams, being able to draw on a case study example in an analysis or opinion question can be really useful. And I think that there is real benefit in reading this chapter. All of these case studies illustrate the operation of online dispute resolution in different contexts. And I think they really contextualize and give a much better understanding than me talking about the theory at this really high level. And they really ask us to really challenge this question: can a machine replace a human judge? So Susskind basically argues that this question is really superficially straightforward and actually is made up of 5 other questions. So in short, he's been arguing since he began writing in this space that we'll always have human judges for the complex and the bespoke, absolutely. But in order to work out whether we can ever really replace a human judge, we need to ask ourselves first, is it technically possible for machines to replace judges? Now, that is changing day to day, hour to hour. We've spoken about Moore's Law a little bit earlier. So I think we can put a little tick there and say, yeah, it probably is. It is probably technically possible to do this. So even if it is, so once it's technically possible, the next question becomes, is it morally acceptable for machines to take on any judicial functions at all? Now, this is a much harder question, and it really, your answer to it could be very personal and will go back to the lens that you look at the world through from an ethical perspective, which you thought about back in weeks 1 and 2 and you wrote about for your first assignment. So really going back and thinking, well, what is a lawyer for? What is a court for? And what particular strengths and weaknesses does an online decision-making process bring to that? And can I sit with that as a moral person, as an ethical person? The third question really is inquiry into whether a system, an ODR system, would be commercially viable. So would the economic benefits outweigh the costs of putting it together? Now, courts are notoriously underfunded. There are very few votes in getting more funding into courtrooms or into prisons. So this is a really important question because in order for it to be funded, ultimately we need to be able to see that it can be done in a cost-effective way. The fourth question is a really tricky one. Would it be culturally sustainable? Could the systems that are used be assimilated without rejection into court institutions that are dominated by age-old procedures with human judges at their core? It's already scary enough for you as you're doing a law degree to ask the question, will I be replaced in the longer term by some form of technology? And I think if you've learned anything across this semester, I think you've probably learned that my opinion is it's actually unlikely that you will be. The job that you do will be different, though, from the job that I did. And the job you start out doing will be very different from the job that you end up doing in the future. There's absolutely no doubt about that. I think judges are in the same boat. I think what we would see with the less complex, more automated, the administrative work being taken away from judges, they will be doing more complex work. That's not going to go away, but we will be seeing more satisfaction overall with the judicial system. And then finally, Apologies. Finally, there's also a philosophical question. Is it jurisprudentially coherent to develop a system that could replace human judges? Is there anything specific about the structure and the nature of judicial decision-making that places the idea of a court itself, either partly or entirely, beyond the scope of computation? And that's really the focus of a lot of the research. And I think all of us will have slightly different points of view in relation to that. So when thinking about technical feasibility and whether a robot judge can replace a human judge, Susskind ultimately argues that commentators fail to draw distinctions between the systems that seek to copy the way judges' work is done on the one hand, and then on the other, systems that deliver the outcomes we expect of judges, but do so in distinctly unhuman ways. So we need to actually think, as we're thinking about technical feasibility, and we're thinking about what it means to be a human judge, we actually have to unpack what human elements of judging do we need to stay. Does a machine think, work, emote, create, reason, feel like a human judge? Right now, I think the answer to that is a resounding no. Do we need it though? Can the outcome of judicial methods be delivered by machines? At the least complex, I suspect that the answer to this is probably yes. And is it possible to develop systems that deliver the social and economic outcomes that we expect of judges and the courts, but do so in these unhuman ways? Debates about the desirability of artificial intelligence replacing judges tend to denigrate into these arguments over what might or might not be technically possible. Clearly, there are some human tasks and activities that are so important to the human condition that we would never be comfortable in allocating them to AI and to autonomous machines. But there are also some that, and in particular around decision making, which sits beyond a moral boundary, if you will. If the liberty, health, or wealth of citizens is to be reduced by the state, is it important that we have another human being responsible for making that kind of decision? Or do we feel comfortable with the idea of that being done autonomously by the bots? It's a really interesting question for discussion, and I really, really look forward to hearing what you have to say. In the next video, we're going to move on and look at some of these ethical decisions in significantly more detail. I'll see you there.